On January 9, 2014, there was a corporate member meeting, as you all know. After the corporate member meeting, the board held an emergency executive session meeting, attended, I believe, by 10 of the 11 directors of this board. In that meeting, the board formed a legal action committee specifically to deal with legal strategy. The action that the board took in that regard, I believe, was passed by a vote of 7-0 with 3 abstentions. So with respect to the legality of handling litigation strategy decisions and actions, that is something that was approved by this board in January at a time when we all understood from a variety of statements made by our sister housing mutual as well as implications of certain actions that litigation was coming. And of course, that sad prophecy proved true. The first statement that's been made about this action was that Third Laguna Hills Mutual filed a lawsuit. That is incorrect. The lawsuit was filed by United Laguna Woods Mutual against GRF Inc. We filed an emergency motion on an ex parte basis to ask to be included in that discussion. That is not filing a lawsuit. The lawsuit already exists. It's important to note, directors, that the judge specifically said yesterday not only that Third Laguna Hills Mutual should be a party to this discussion in court, but that we were actually an indispensable party to the resolution of the dispute. The dispute involves you two. It involves the trust that governs not only United, but the other 2 housing mutuals as well. The court had very little difficulty, and in fact, we didn't have to say much because the judge felt that Third should be included in the lawsuit. So that is how the intervenor was filed, and now Third will have the right to appear in court next Monday at the hearing on the preliminary injunction to express Third Laguna Hills Mutual's position. That position, I think repeatedly by this board, has been that we oppose the lawsuit, that we believe the lawsuit was unnecessary, that we believe that the mutuals should be working together. Those resolutions were passed in the January meeting of this board. There were motions in the March meeting of this board as well to that effect. And there have been numerous correspondence from my office. There have been numerous attempts by different members of this board to try to ask our sister housing mutual to work with us. So it's rather ironic that the board is being accused of fostering litigation when in fact the litigation was started despite our requests, despite our repeated entreaties by our sister housing mutual. What has changed since January, of course, when you told United Laguna Woods Mutual that you favored the concept of the amendment, but you didn't favor how it was being pursued. You also passed a resolution in that meeting that asked United to work with you to resume the task force project that Mr. Juhan was part of and get back to amending the trust. That was unsuccessful, as we now know. That's what's changed since January, is that our sister housing mutual has decided not only not to work with Third, but to declare war, lawsuits or war, against GRF. The issue about divisiveness is an important one. I absolutely teach, counsel, and write against divisiveness in community associations. That is why this board since January has been urging United not to do what it's now doing. So it's ironic that you're being accused of fostering divisiveness when you're not the ones that started this conflict, and when you have been asking your sister corporation to work with you for quite some time. The accusation was made to you this morning that the judge will not consider third's opinion as important. So the great irony today is that had we all worked together a year and a half ago to modify the trust, we could have very well had a reasonable discussion to limit JRF's power in the trust by amendment, by cooperation, with respect to construction or destruction or acquisition or disposition of real property. And the really sad irony today is that not only are we not any closer to that goal, but we're farther away from it, because now we're at legal war, and for who knows how many months, until a judge finally decides this case, we won't be able to return back to the process that Jim Juhan and the task force began. That's extremely unfortunate. With respect to the minutes or the transparency of this board, I don't recall seeing any videos of open meetings of the United Board where they discussed the lawsuit and why they should do it or why they shouldn't. I don't recall Mr. Beaumont's discussions with his client being aired out to the entire United community. So I don't see anything inappropriate with keeping our discussions about litigation and attorney-client matters privileged in this board. Again, it's ironic you're being accused of a lack of transparency, and I don't think that's fair. Lastly, with respect to directors being misled, I think you all know very well what you decided on January 9. The minutes are certainly available to you of executive session minutes documenting that decision. I strongly believe that this board is taking the correct action for the community. I believe very deeply that the lawsuit is a legal mistake as well as a community mistake. I think that there is going to be a time when we're all going to be able to work together again, but you don't work together by suing each other in court. And that's, I think, really the message that if you read the intervener that we filed yesterday, that's really our message, is that we deplore the fact that the joint task force project, which would have addressed this very issue, not the clubhouse issue, the bigger issue of JRF's power, that has been abandoned for a year and a half now, and that really is the way to handle this dispute, not by dividing the community and not by spending money. I do not anticipate our involvement in this lawsuit will be major. You will note that our little opposition, I think, was 8 pages long. So again, I think it's ironic that when we're not the ones that started the lawsuit, that you're being pilloried today in the meeting about wasting or spending money unnecessarily. We're the ones that have been saying since January, please don't do this, please don't waste money, please don't fight, let's all collaborate. And now you're being pilloried for the exact thing that you haven't been doing. So anyway, that's my report on where we are right now. The hearing is on next Monday. I have no problem in saying I do not anticipate the preliminary injunction will be granted. It's hard for me to imagine how it could, but United is entitled to its day in court, and we're entitled to our day in court to tell the judge why it's a bad idea, and that's what we will be doing on your behalf.
Thank you.